Welcome to another edition of Work Comp Matters videos, where we have experts in the field of workers' compensation, employment, and labor law come in and briefly talk about workers' compensation, employment, and labor law. We're brought to you by A1 Law, the #1 computer management system in workers' compensation. And now, without further ado, talking about the overlap between workers' compensation, employment, and labor, applicant attorney extraordinaire, Mr. Michael Burgis. Hello, Michael. It's a pleasure to see you.
Thank you, Steve. Thank you for the introduction.
Thank you.
So off air, we were talking a little bit about employment law, and I just want to discuss a little bit about that with the viewers or listeners. First off, employment law and workers' comp, very synergistic. I would use the phrase inextricably intertwined. And I will say for the listeners who are in the work comp industry, if you don't fully understand employment law, I think you might be doing some injustice to your client unknowingly. So I want to briefly just state what the position.
I think the classic example is in a workers' comp case, agreeing to a resignation when you do a compromise and release, because therefore, and Michael, you tell me, you foreclose all of your rights you have towards an employment lawsuit. Is that correct?
You hit one of the biggest nails on the head. This is something that makes me disgusted. I will be at the WCAB, and I will hear people left and right sign voluntary resignations, and it kind of sickens me a little bit, and I'll explain why that is such a bad thing, and I will put it into some real-world examples of cases I've litigated. So first off, remember that in employment law, a quick synopsis is when an employer has knowledge that one of their employees is injured, whether it's work-related or not is irrelevant. But whenever an employer has knowledge that one of their employees is injured or has disability, they have a legal obligation. Okay, I'm an employer. I find out one of my employees is injured. My legal obligation is I need to engage in an individual interactive process, and I need to figure out what's going on. And I'm legally obligated to make all reasonable accommodations so long as it doesn't represent a quote-unquote undue burden on me. Now, let's talk about that for a second. We all handle workers' comp cases, or a lot of us here handle workers' comp cases. They report injury, discrimination, retaliation, failing to engage in that interactive process, failing to make reasonable accommodations. I would say this happens more often than not. And I will tell you that I rarely see an employer do everything correctly. So ultimately what happens is this. Let's say a workers' comp case is filed, litigated, and ultimately settles by CNR. What happens is the applicant attorney will ultimately sign settlement documents, and in there is inevitably a voluntary resignation. As for the viewers and listeners, almost all defendants are going to want that, and actually rightfully so. The employer wants, and the carrier wants to make sure that if they're going to buy out the future medical in a compromise and release, they want to make sure they're off the hook and they're off their exposure. And as we know, while permanent disability may be apportionable, future medical is not. So if you were to CNR a case, buy out the future medical, be done, but that client was still working for the same employer.
There starts his day one of his new CT.
Exactly. And assuming they're still insured by the same insurer, if they're not going to care about a voluntary resignation. But if that's the case, all they have to do is aggravate any of those injuries by 1%, and it's a relatively easy burden to prove. Then the insurer is back on the hook for the money they literally just paid out in CNR. So I don't fault the defendants for requesting this or wanting this. The issue here is the verbiage in the quote-unquote voluntary resignation. One, it should never be a voluntary resignation. And it should never say that the person is voluntarily resigning.
What I do on my cases is I very much encourage the defense attorney to recommend to his client something to the effect of, the parties have agreed to an employment separation. That way, it doesn't say he resigned, quit, or anything. It's a separation of employment. What's your take on that?
That's exactly what you should do. It should be called a separation agreement, and it should just simply say, I, applicant, am not working and will no longer seek rehire. Now, if you say, I am not working and will no longer seek rehire, that contractually gives everything the carrier that they need. He's not working, he's not going to seek rehire, they're off the exposure. Okay? But saying that I'm not currently working and I'm no longer seeking rehire, nothing in there is voluntarily resigning. You're not. The problem is whenever you voluntarily resign, you are cutting off all damages from a potential employment law, wrongful termination, retaliation, failure to engage in the interactive process. So you got to be very careful about that. And then, one of the other issues is, so once again, an employer is legally obligated to engage in an individual interactive process. They're legally obligated to make all reasonable accommodations unless it represents an undue burden on the employer. Now, what's going to happen is, if you go to file that civil lawsuit, or somebody else is filing that civil lawsuit, and you just signed a voluntary resignation, you're going to get a pretty upset phone call from that plaintiff's attorney saying you just cut off all damages. And that plaintiff's attorney, if they know what they're doing, they're going to tell their client to find a malpractice, professional malpractice, and sue you. And this is the one area in workers' comp where you can actually get hit for malpractice fairly easily. And it's in all those addendums, those general release language. Any addendums in a settlement, don't sign general release, don't allow any of that language in.
The dastardly 1542 clause, I think it is.
Yeah. But let's talk about.
Well, actually, if you don't mind, when we were off camera, you were talking about specifically temporary disability, or TD, and overlap between workers' comp and employment.
And let me. That's a great transition. So let me discuss that for a second. How often do you see this? You see an injured worker who gets probably wrongfully terminated, goes to a physician, and this physician feels bad for this person, knows that they have a legitimate case, knows that they probably just got wrongfully terminated, and so what does that physician do? They say, I'm going to help this guy out, and I'm going to find this person TTD so they can get EDD benefits. That is a potential significant problem in an employment law case.
Well, first off, it's fraud if it's not true, but go ahead.
Agreed. So one, I will tell any applicant attorney or employment law attorney that's listening to this, one, I agree that's fraud, because the doctor should never find somebody temporarily disabled if they're not. But two, remember, if there's temporary work restrictions and the employer's not accommodating, they're legally entitled to TTD regardless.
Which is, for those of you that don't know, is temporarily partially disabled, TPD.
Yes, but they're whether they're TPD, they're still entitled to total.
They're entitled to 100% of temporary disability benefits, because you cannot apportion temporary disability.
Exactly. So ultimately, here, and I'll give you an example of a case. This is a case that I've been litigating for 5 years now, and it has. I haven't even heard of a case that's been litigated more than this, but and I can speak openly about this case in fact pattern, because it's a public decision. The case is called Noe Arbarca versus Citizens for Humanity Gene Company. Okay, 7 for All Mankind, Citizens for Humanity. This is a very fancy gene company that a lot of people have these genes. They're very expensive. My own personal opinion is you should never buy these genes. It's a shady company. That's my two cents here. But my client, Noe Arbarca, hardworking Hispanic gentleman, working for this company for about 6 years. All he does is lift boxes, take them out to the QA department, pass them out to the girls who inspect it, and then when he's passed out of the boxes, he inspects his box. He's working for, 3-4 years, starts to get a shoulder pain. Mind you, he's repetitively lifting boxes on a daily basis, full-time plus overtime. His boss says, well, no way, you can't work, you don't have a job. Clearly didn't engage in an individual interactive process, clearly didn't attempt to make reasonable accommodations, and in fact threatened him. So it's retaliatory and discriminatory. But this poor gentleman, Spanish speaker, sucked it up, worked for like another year. Finally, the pain is so unbearable, he goes to his boss and actually goes to the HR department and says, hey, my shoulder's really bad, I need to see a doctor. They say, go to your personal doctor. Clearly, what they should have done is it's obvious that this is potentially a work-related claim. They should have provided a claim form. They didn't do any of that stuff. And he goes and sees a doctor. The doctor gives work restrictions of like no lifting more than 15 to 20 pounds for 30 days. He takes this in to his employer, and I could tell you that his employer right then said, we need to get rid of this guy. But what do? Oh, he has work restrictions for 30 days. Everybody thinks that, if they terminate him there, they're in trouble. So they wait one business day after the work restrictions end, and they let him go. And they say, work slow down. Okay? They bring him in. He's begging for his job, and they're saying, nope, you got to sign this. We're letting you go. And he's begging for his job, and then he finally says, well, what about my shoulder? I need to see a doctor. And they say, I'm sorry, are you reporting a work-related injury for the very first time after you've been told you've been terminated? And so for our viewers, there's something called a post-termination defense, and that is, post-termination defense is a proper and good thing, because we shouldn't have people who are disgruntled and filing BS work comp cases because they're disgruntled. So if you file a workers' comp claim after you've have knowledge of termination, you're going to lose unless you can show that you reported it previously, that you treated for it previously, or there's the CT exception that you didn't really know, there wasn't a concurrence of injury and disability with sufficient knowledge. But so what are they trying to do? They're trying to set up a BS post-termination defense. And so they make him sign in Spanish, I am for the first time reporting a work-related claim after I've been told I've been terminated, before he gets his check. And then they deny the case and they fight me to the death on that. The funny thing is, there's a spot on that claim form right above that says employer's first date of knowledge. They put that date. He turned in work restrictions 3 days before. Definitively, we could prove that the employer was lying. So this is a case that I handled both the workers' comp case and I have litigated the wrongful termination case, including doing a month-long jury trial where I went against one of the most elite defense firms on the planet with an extremely high win ratio, and they basically tried to paper me to death. Motions for summary judgment, 1 million motions in limine. They deposed everyone and their mom, 8-hour videos videotaped, hired 1 million experts to combat mine. In fact, they hired John Stahlberg as their expert to counteract Dr. Neharayan's testimony about the wrongful termination causing stress, depression, and anxiety. So ultimately, on this case, I could clearly show, in my opinion, that he was wrongfully terminated, retaliated, and discriminated. And so we did a full-on jury trial. And I'll say one bit here for the viewers is that individual employment law cases are very difficult. They're very litigious. They cost a lot of money. But I will tell you that there is a huge propensity to get monetary justice for your clients in civil that we don't see in the workers' comp arena. And that is, you can get pain, you can get suffering, you can get full lost wages, and you're ready for this? You can get punitive damages. And so I will tell you that I came up with a little theory on this case, and it worked. Okay. So remember that punitive damages in the civil arena, you have to show that the defendant acted with malice, oppression, or fraud. But you have to show that it was the owner of the company or a managing agent that made or ratified the decision. So of course, what happened in Noah Barca's case, they claimed later their position was he was a horrible worker. We terminated him for being a horrible worker for good cause. They said, one, we did engage in individual active process. Two, we didn't have to make reasonable accommodation because the box he lifted were under 20 pounds, which is absurd. Then they said, we fired him for good cause. And, but even if we did anything wrong, two big defenses. His primary treating physician found him totally temporarily disabled. So even if we did act illegally, there are no damages because the damages in the employment law cases, but for their legal action, but for their failure to engage in the individual interactive process, but for their failure to make reasonable accommodations, but for their wrongful termination, retaliation, discrimination, he would have continued to work. Those are the economic damages. And they're saying, but the doctor found him totally temporarily disabled. So it bars any economic claims. Then they said, and ultimately it was a low-level supervisor that made the decision, so we can't be on the hook for punitive damages. Now, I will tell you what I did there is I sent a letter to the employer saying to the managing agent, hey, please conduct a good faith investigation. I think my client was wrongfully terminated. Take him back. So they're legally obligated to take that investigation. And what I did at trials, I put the managing agent on the stand. And I said, listen, you know all the facts. You conducted an investigation. Still think you did everything right? So at that point, he can only do one of two things. He could admit fault, and then we just won liability at trial. Or he says, no, we did everything right. And what do you think he's going to do? He's going to say he did everything right. And then the next question you're going to say, so you're ratifying the decision of that low-level employee. What can you do? When you go into jury instructions, literally the question is, did the employer failure to engage in the individual interactive process? Did they fail to make reasonable accommodation? Did they wrongfully terminate, retaliate, in violation of public policy? There's a whole jury instructions. And then one of the questions will say, did defendant act with malice, oppression, and fraud? And I will assert to you in any employment law case, yes, that's of course what they're doing. Then the next question is, did a managing agent make or ratify the decision? You just did it at trial. And then on a very small case, by the way, this case, I did a 998 for $150,000. And for the viewers who don't know what a 998 is, it's basically saying, hey, here's my most reasonable demand. Pay me this and we're done. But if I go to trial and win $1 more,
$1 more. Yeah.
you're going to win. You're going to have to pay all of my expert costs. And so I tried to come up with the most reasonable number for my client that I thought was adequate. Now my client was a minimum wage worker, had something that happened subsequent to his wrongful termination that took him out of the workforce, so I had very small economic damages. The jury awarded $100 in compensatory damages, but then awarded $550 in punitive damages. And here's the kicker that I want the viewers and listeners. You get statutory attorney fees under FIHA if you win a cause of action under FIHA. So if you can show the employer failed to engage in the individual interactive process, failed to make reasonable accommodations, retaliated or discriminated, you get statutory attorney fees on top of your percentage.
And now all you need, if I'm not mistaken, are at least 5 employees for it to qualify for Fiat, correct?
Yes, and I'll tell you that determining, I'll tell you right now, if you have a very small employer, you should be very hesitant to file employment law cases because one, the smaller the employer is, the more likely it actually is an undue burden on them to make reasonable accommodations.
And two, if you win a big suit, they're probably going to go bankrupt, go out of business, and they won't be able to pay anything.
There you go. That's you can't get blood from a stone. And I will tell you then also, if you're going real big, punitive damages, remember what they're designed to do. They're designed to do 2 things: punish and deter.
Right.
And in order for that to happen, it needs to sting. So what happens if you get punitive damages, you go into phase 2 of your trial. Your jury's going to hate you because your jury's thought they were done. But then they go into phase 2 where you put the financials of the company on the stand and then you basically pitch the jury. Listen, if you give $100,000 in punitive damages to a company whose gross revenue is $10 billion, do you think they're going to feel that? Do you think that's going to punish them? Do you think that's going to deter them? It needs to sting. That is how you can get a ridiculous punitive damages award that will get upheld. And there's some recent case law that's basically upholding some very, very high numbers. Carney Shagirian, David Burgis, a few of these employment law, courtroom, Arsh Hamapour, these guys are just absolutely killing it in that because they're not settling a case cheap. They see the big picture and they're gearing up for trial to get justice for their clients.
That is a fantastic way to end this show. You want it to sting, but you don't want to kill them. It's been a pleasure having my expert guest, attorney Michael Burgis, for my guest. My name is Steve Appel, and this is Work Comp Videos.